Hi there, my name is Francois Ace from the firm Francois Ace Incorporated Attorneys. In this episode I will be dealing with the difference between a voluntary surrender of estate and a forced application, or friendly as it is also called. Firstly, with a voluntary surrender of estate, the application is done on affidavit only. It's called an ex parte application. This is a court order which takes more or less 6 weeks to obtain, depending on the dates which is available at court. The court appearance would be done by an advocate and not yourself. The applicant will not appear in court. The burden of proof in a voluntary surrender is advantage to creditors, which amounts to 20 cents per rand credit. The second way of being sequestrated is one of forced sequestration, or so-called friendly sequestration. This is done where there is an applicant, which might be a creditor or usually would be a creditor, that applies for your sequestration. Now, forced would mean that a creditor can on his own accord apply for your sequestration, and he would then serve the application on you by way of sheriff service. This is a two-part application where there is a provisional court order and later on there would be a final court order. Why the confusion between forced sequestration and friendly sequestration is merely depending on who the applicant in this application is. As you know, when falling on difficult times, normally friends and family would assist by giving money to you or to a person to help. This is not normally enough, so there is loans created and money is given to a person who is indebted. This would mean that even though it is a friend or a family member, there is still a credit given and he is a creditor in your estate. His intention would not be as fierce as a forced sequestration, which might be a bank for example, but he may in any event apply for your sequestration on the basis that he is a creditor in your estate. In order for this applicant to apply for your sequestration, you need to inform him that you cannot afford to satisfy this debt that he has against you. That would then mean that he has a cause of action against you, you are unable to satisfy this debt, and that he may then apply to court for your sequestration. The consequences of any of these two applications and obtaining a court order on either one of them are exactly the same. As soon as the final court order is granted, you would be sequestrated and all the advantages would apply. Once you sequestrated, the court would then appoint the trustee on your estate who will deal with all your creditors. Normally the voluntary application would be applicable where a person has immovable or movable assets which the bank or a creditor has already foreclosed on. Hence, you can then prove the 20 cent rand dividend in the application. This would not be necessary on a forced application.
This video is intended for informative purposes only and should not be considered as legal advice specific to your needs. Please arrange a first free consultation to consult one of our attorneys in person.